Good afternoon, friends. Please take your seats. We are about to begin our next session on IBC. Please. Hello. Hello. I am CA Rajendra Kumar Agarwal, Chartered Accountant, IBC, Insolvency Professional and Registered Valuer. I truly feel honored to welcome you all to this seminar on rethinking stakeholders' value and our IBC valuation. In today's rapidly evolving landscape, stakeholders' value is not merely a financial calculation. It is a delicate balance of law, commercial wisdom, valuation principles, and larger economic vision of our nation. And to explore this theme, we are privileged to have with us some of the most respected experts and thought leaders of the industry. I now welcome CA Jyoti Prakash Gadia, MD Resurgent India. Please, sir, come on the stage. Jyoti Prakash Gadia. Jyoti Prakash Gadia, sir. Thank you, sir. I welcome Sri Rohit Kapoor, a former NCLT judge. Sir, we are privileged to have you with us. Kindly join us on stage. We welcome Sri Jitender Lohia, eminent insolvency professional, our very own member, who will be moderating this session. We now welcome CA Nitin Daga, senior insolvency professional. And last, our lady advocate. Welcome to Advocate Tanya Baranwal. We are glad to invite you on the stage, ma'am. I would like to felicitate our speakers, all learned speakers, with a memento, please. Memento, please. I invite lawyer Rohit Parasrampuria ji, please felicitate Sri Jyoti Prakash ji Gadia. Request CA Tulsi Tibrewal to welcome, felicitate Sir Rohit Kapoor. Hello, आइए हॉल में. I will request Ms. Resmi Chaucharia to present a felicitate Mr. Jitender Lohia. I request CA Satish Patodia to felicitate Nitin Daga. आइए स्टेट करिए मैडम. अरे, I just got your name. भूल गए. Anil ji, please felicitate our young advocate. Now, I hand over the mic to our moderator, Sri Jitendra Lohia. He will moderate the session for at least half an hour or 35 minutes approximately.
I think
Okay.
we have 60 minutes of this panel.
Yeah.
No. हम लोग स्ट्रेस में डिस्काउंट नहीं लेंगे.
Satish ji, please come on stage. Come on stage.
Right. So it's up to me. So as long as you see the audience are interested, we'll continue with this session. And thank you. So with this, a very good afternoon to all. And I must thank EIRC for giving me this opportunity to moderate this session on rethinking stakeholder value under IBC. Let me also welcome our panelists for today, Sri Rohit Kapoor, former judicial member NCLT Kolkata, Sri CA Jyoti Prakash Gadia, MD Resurgent India Limited, one of the largest stress asset resolution company in India, Advocate Tanya Barnawal, Associate Partner, Indian Law LLP, CA Nitin Daga, Insolvency Professional. So today we'll be discussing on a very pertinent topic, rethinking stakeholder value under IBC. IBC, friends, all we understand over the maybe decades, 9 years has passed since IBC was brought in. It's no longer about the timely resolution, right? It's about the balancing, maximization, stakeholder value. But now, today, whether it is a time to think that who the stakeholders are, whether it is only a financial creditor, we call them a stakeholder, or the value which is they can recover under this CRP or insolvency process, whether it is a right value, whether the other stakeholders like operational creditor or even promoters, whether they are not the stakeholders in the corporate data. So it's a time that we rethink the entire process or maybe brainstorm so that from here on, we all represent this law to be successful in a various forums so that we can, contribute our bit and how we can make this law more better and acceptable so that the intent with which this law was enacted could be achieved, right? So the data also suggests the recovery which was initially more than 40% when during 2017 and 18 when the dirty dozen cases came up along with many insolvency invoked on many large corporate data, the recovery was more approximately around 40%. Then it dropped below 30%. Now it is consistently below 30%, and in even some of the large cases, the recoveries are merely 2 to 5%. So whether this is what we wanted or whether the value was exaggerated over the years, wherein the principal amount was much lesser than the amount claimed and the value or the recovery which is calculated is fictitious. So we have to put our brain so that we just rethink how this process is being run. Whether the stakeholder under the IBC, again a pertinent question is the other stakeholder like OC, like are they stakeholder for a namesake? Because generally we have seen over the years they do not get anything. Even 1% is not recovered by them if the company goes into insolvency process. Yes, there are cases wherein the insolvency is withdrawn even prior to CIRP commencement. So that is where they can recover something. But during the process, they are basically getting a nil or a negligible value. Then the delays and litigation. Earlier there was a, when the law was enacted, it was enacted in such a way that no, the court will have no say in that. Once the case is filed under section 14 or, section 7 or 9, the case will be admitted within 14 days. Now, over the period, we have seen that no, this is not mandatory, this is recommendatory. Many judgment has been passed by the highest court. And along with that, it is plagued with lot of litigation by all these stakeholders who have a varied interest in the resolution of the corporate data. So you'll see we have a very esteemed panelist over here. So we'll start with each panelist for giving their opening remarks on the topic. We call it a landscape and reality check. Now, what is the situation currently we are having in hand? So let us start with, we'll have 4 minutes to each of the speakers. So please do maintain the timeline. So let me not, stop you over there because we already have a time constraint because of delayed program start. So we start with Mr. Rohit Kapoor, sir. Sir, from a judicial lens, how has the concept of stakeholder value evolved through NCLT and CLET judgment? You have been in NCLT Kolkata bench and we have seen a lot of great judgment through you. So do you see a shift from creditor primacy to more balanced view?
Hello. Institute of Chartered Accountants of India, Eastern India Regional Council, its office bearers, the learned professionals, my co-members on the panel. First of all, thank you very much for having me here today. Sharing very briefly my experience on the bench now as a practicing lawyer. As for the concept of stakeholders, value, I would say, not only the NCLT or the Honorable Supreme Court, but also the NCLT, because the proceedings originate from the NCLT. They have played a very important role in the evolution, because initially I'm conscious that there were many areas which was not clarifications, but over the time, with the assistance of the lawyers, the professionals, the courts, the tribunal have been able to interpret, and so there has been an evolution, and this is an evolving process. We continue to evolve. And now we all know that there is a draft legislation also. There are some amendments. So it's a continuous process. We learn by the experience. And there are judgments from the Honorable Supreme Court. You all know that after the resolution process, it's a clean slate, though the word is not as such used, but by the Supreme Court. And then there are many other judgments. We have seen recently the Supreme Court, how they had to intervene in a review in a Bhushan Steel matter because of the doing the justice to the parties. And we see in the preamble only of the insolvency, there is a words used, balance the interest. So balancing interest is the ultimate objective, along with, of course, the maximization of the assets. And as far the shift is concerned, I would say that the COC remains the major player, I would say. And the interest of others, of course, as per the law laid down as on today, the NCLT, as I told you, the Honorable Supreme Court in Bhushan Steel, just to watch the interest of everybody, they intervened, and it's an evolving process, and we continued with that only.
Right. So, as I said, the law is still evolving, and we are into 9th year of the law. Mr. Gadia, next question to you about the topic which we have chosen for today. Vis-a-vis, just to elaborate on how distress firm, when we talk about post-resolution, right? So how distress firm which are being taken over has seen meaningful and durable gain under IBC. Are we seeing an operational turnaround? I mean, is it good for the economy, or maybe the person who has taken over? So what's the view on that?
Sir, sir का क्वेश्चन ये है कि whenever the any stress firm which are taken over, तो taken over के बाद में उसके क्या value addition हुआ? Just एक example दे रहे हैं. We launched our own AIF last year in the stress asset fund, और उस समय भी collected all the data of the company. जब fund raising के लिए जा रहे थे तो investor को दिखाने के लिए बहुत सारा data collect करना पड़ता है. There were not even a single company which my analyst could find out that any company which has taken over in IBC and which has, जिसके अंदर में उस investor ने पैसा lose किया है. Whether it is the same promoter, whether it is the investor, whether it is anybody, तो हमें लगा कि सर बहुत अच्छी चीज़ लेके जाएंगे तो वो इन्वेस्टर बोलेगा कि आप तो खाली गलत बात बता रहे हैं, आप कोई गलत, you are not showing anything negative into the presentation. I am just trying to say that we were raising fund for ourselves. My analyst came back and said, कि sir, not even a single company which he could find where there was a negative return of the capital which was eroded. That was only there. Only there were some complications in 1 or 2 real estate cases which were taken over because of some home buyer restrictions coming in and some of the things which are coming up that way. Apart from that, there were nothing else as such. Secondly, how the stress industry has evolved, I can say that we also have a loans syndication department, जहाँ पे कोई कंपनी यदि आके यदि कोई एक्वायर करना चाहती है तो हमको आके बोलती है कि आप मेरे लिए पैसा रेस कर दो. तो 4 साल पहले, when the company used to come to us 3 or 4 years before, if any company which is acquiring any stress asset from the bank or from any other methodology, suppose कर लो वो 100 करोड़ में acquire कर रही है, he is asking us कि सर मेरे को 40 करोड़ रुपया रेस कर दीजिए, 30 करोड़ रुपया रेस कर दीजिए. 4 साल पहले तक the amount of fund that was available, जो देने वाले लोग थे बहुत ही कम हुआ करते थे. मतलब there were only hardly 2 or 3 fund, and I could never see that the rate of interest at any point of time was lower than 24% 3 साल पहले. Last transaction we did last month, the rate of interest was 9%. Last transaction we did, the rate of interest was 9% for the acquisition of a stress asset, and acquisition amount का 90% was funded. Please, earlier the acquisition amount का 50% fund होता था 3 साल पहले और 24% ब्याज लगता था. Last month में acquisition amount का 90% fund हुआ है और उसका rate of interest 9% है. And you will also be very happy to understand that fund institution like IFC is also now funded one of the stress asset acquisition funding. Regarding जितेंद्र जी साहब ने बोला कि स्ट्रेस एसेट के अंदर ना वैल्यू बहुत ही कम होती जा रही है बिकॉज लोगों को लगता है कि बहुत ज़्यादा हेयर कट लेना पड़ता है. मैं आपको खाली 2-3 एग्जांपल दे रहा हूँ एंड दिस हम लोग तो भुक्तभोगी आदमी है कि हमने फंड बनाया और हमको एसेट ही नहीं मिल रहे हैं. तो मैं आपको मेरा एग्जांपल देता हूँ कि हम लोगों को कैसे हेयर कट की क्या सिचुएशन है. ये खाली परसेप्शन फैक्टर है कि रियल के अंदर में हेयर कट हो रहा है कि नहीं हो रहा है कोई चीज़ के लिए. तो एक IBBI का स्टैटिस्टिक्स है, वो तो खाली मैं स्टैटिस्टिक्स दे रहा हूँ, देन आई विल कम बैक टू द प्रैक्टिकल सिनेरियो ऑल्सो। दिसंबर 2024 तक लगभग 1100 कंपनीज का रेजोल्यूशन हुआ है, और जिसमें 11.5 लाख करोड़ का प्रिंसिपल अमाउंट स्टैंडिंग था। प्रिंसिपल अमाउंट मीन्स उसके अंदर ब्याज पे ब्याज सब कुछ ऐड करके 11 दिसंबर 24 तक उसका 11.5 लाख करोड़ का आउटस्टैंडिंग था जितेंद्र भैया। उसके अंदर में जो बैंकों ने जो एक फेयर वैल्यू लगाते हैं हम लोग और एक डिस्ट्रेस सेल वैल्यू लगाते हैं, रोहित सर और आप लोग सब काम करते हैं, नितिन भैया, तो एक हम लोग फेयर वैल्यू लगाते हैं कि अप्रोक्सीमेटली उसकी फेयर वैल्यू कितनी होगी। फेयर वैल्यू आई हमारे पास में 3.2 लाख करोड़, तो 11 लाख करोड़ की फेयर वैल्यू थी 3.2 लाख करोड़ और डिस्ट्रेस सेल वैल्यू थी 2.2 लाख करोड़, ये था। यदि हम लोगों का यदि ये एवरेज रियलाइजेशन 1100 कंपनीज का, मैं तो ओवरऑल की बात कर रहा हूं, मैं अभी आपसे कुछ स्पेसिफिक एसेट की बात ही नहीं कर रहा, दिसंबर 24 तक, 1.5 साल में तो बाजार और मैच्योर्ड ही हुआ है। दिसंबर 24 तक 11 लाख करोड़ का प्रिंसिपल आउटस्टैंडिंग था, जिसके अंदर ताम झाम पेनल इंटरेस्ट फलाना दिमकाना सब लगा के रखते हैं। उसका फेयर मार्केट वैल्यू था 3.2 लाख करोड़, डिस्ट्रेस एसेट वैल्यू था 2.2 लाख करोड़। ये सारे आज तक का जितना भी रेजोल्यूशन हुआ है, तो यदि हम 3.2 से कोई कम रियलाइजेशन होगा लाख करोड़ का, 2.2 से होगा, तब हम लोग बोलेंगे कि हेयर कट हुआ है। The realization, total realization is 3.6 लाख करोड़। सब आप यदि प्रिंसिपल से कंपेयर कर रहे हो 11 लाख करोड़, तब आपको 3.6 कम लग सकता है। स्टैटिस्टिक्स इज अ मिसनॉमर ना, आप उसको कैसे देखना चाहते हैं उस नंबर्स को सर। यदि आपका प्रिंसिपल वैल्यू, बैंक तो प्रिंसिपल वैल्यू पे बात कर रहा था, फेयर मार्केट वैल्यू इज एब्सोल्युटली कि सर आज के दिन में रीजनेबल रिटर्न के हिसाब से फेयर मार्केट वैल्यू इज 3.2 लाख करोड़। बैंक्स हैव, ऑल द इंस्टीट्यूशंस टोटली हैज बीन एबल टू रियलाइज 3.6 लाख करोड़। मैं आपको 3 एसेट के एग्जांपल दे रहा हूं। पावर प्लांट विच वाज अवेलेबल एट अप्रोक्सीमेटली 4 साल पहले 1.2 करोड़ पर मेगावाट में पावर प्लांट मिलता था। लास्ट पावर प्लांट का डील हुआ है 4.1 माने 1 करोड़ पर मेगावाट। 1.2 करोड़ पर मेगावाट की जब पहला पावर प्लांट बिका, 1.2 करोड़ पर मेगावाट में बिका। लास्ट पावर प्लांट की डील हुई है 4.1 करोड़ पर मेगावाट में। सीमेंट प्लांट पर टन के हिसाब से जो डील होती थी, उसकी प्राइस जो 3 साल पहले और आज की पर टन कैपेसिटी के अंदर में 4 गुने का फर्क है। 4 गुना 4 साल के अंदर। जिस प्राइस में 3 साल पहले जो सीमेंट प्लांट बिका और आज जो सीमेंट प्लांट के जो कोटेशन आ रहे हैं, अभी मैं आपको बताऊं कि लास्ट 1 साल के अंदर में हम लोगों ने कम से कम, मेरे को लगता है कि मैं खाली अपना एग्जांपल दे रहा हूं, मैं तो बाजार की दुनिया की बात ही नहीं कर रहा हूं। I am saying that we might have participated in approximately around 90 और 91 RFPs जो भी आए फॉर्म जी में पार्टिसिपेट किए। फॉर्म जी के अंदर अपन ने पार्टिसिपेट करके अपन EOI भरा, रेजोल्यूशन प्लान तक गए। मेरी टीम मेरे को आके बोली कि सर हम लोग इस एसेट के लिए यदि हम 100 रुपए तक बीड कर सकते हैं। मेरी टीम ने एवरेज यदि बोला कि हम 100 रुपए तक बीड कर सकते हैं। मैंने उनको बोला कि सर आप 125 तक बीड कर देना, इन्वेस्टर के पैसे हमारे पास रखे हैं, कुछ कहीं तो इन्वेस्ट करना पड़ेगा नितिन भैया, इन्वेस्टर के पैसे रखें। मैं उनको बोला कि वो बोले कि हम 100 तक बीड करेंगे। मैंने कहा आप 125 तक बीड कर देना। एक्चुअल प्राइस रियलाइजेशन वाज 375 जो हमने हमारी बीड निकाली है। इट इज डोन ऑल द 91 एसेट जिसमें रिसर्जेंट इंडिया ने बीड किया। मेरे ऑफिस वाले ने कहा, माई टीम टोल्ड कि सर आई कैन बीड अप टू 100 रुपीज। द एवरेज आई टोल्ड देम कि अपन 125-150 तक जाएंगे। फिर हमने देखा कि हमको मिली नहीं तो किसके पास गई, उसका क्या रियलाइजेशन हुआ सर, वो 375 था हर एसेट के अंदर में। अब पहले बिकॉज अभी तक क्या है कि स्ट्रेस एसेट लोग इसको ना कबाड़ी मेंटालिटी से देखते हैं कि सर ये तो कबाड़ है तो 100 की चीज हमको 25 में मिलेगी, मैं कुछ ठीक ठाक करके उसके अंदर 25 रुपए की चीज को मैं 40 रुपए या 50 रुपए में बेच दूं।
सर बेसिकली नाउ मिस्टर गड़िया सेज कि जो रिकवरी है, द रिकवरी हैज इंक्रीज्ड मल्टीफोल्ड, राइट? सो नाउ I come to Advocate Tanya Barnawal. So bank often anchor the resolution process. In past we have seen. Nowadays bank are basically refusing to go to the CRP or insolvency process because they somehow feel that the value they are getting from the sale of the stress asset or increased time of litigation. So do you think basically that the current framework truly reduce litigation and, as Mr. Gadia says, increase the overall value of recovery? So what is your take on this?
Thank you for asking that question, Mr. Loya. So now, when we see pre-IBC era, so there were companies that were sick and they were sent to BIFER. And then there were recovery processes like OA before the DRT or SARFAESI. So when we compare with that era, definitely this has grown. And, but banks also look towards the value and along with certainty as well and time efficiency, definitely. But when IBC came into the picture, when IBC was notified, definitely it has reduced a lot, as you have also said, that there is a very limited, because banks are also now not very much keen into going, because of prolonged litigations and the erosion of the stressed assets, it is taking time. But as we see, Supreme Court has now very reduced to the challenges and the grounds of challenges that is needed. That they have very reduced, they have very minimizes it, plus with the evolving amendments, as well, IBC, as we see, is evolving. In fact, now also it has, the challenges is the one where banks are little restricted, because as we say that IBC is a very time management, plus it is not a recovery forum that bankers also, and that was not the aim of IBC, that was never the object of IBC. But with litigation and prolonged litigation, definitely there is a challenge that all these stakeholders faces, and the mindset between the stakeholders is also that needs alignment.
Right. I mean, it's good to see an advocate saying that litigation is increased, but it is always, litigation are always good for advocate. And contrasting view from Jyoti, sir, basically, while he says that recovery has increased under IBC. So, but yes, the fact is the banks are still not willing to go into the CRP process. They still nowadays they are preferring surfacey route for recovery of their stress asset. So we'll come to you later on that. Yeah. To Mr. Nitin Daga, he is an insolvency professional. So you manage actual CIRP, right? So what creates the most friction? You see, litigation comes with friction amongst the stakeholders, be it the committee of creditor, the suspended board of directors, the resolution applicant, relating to the timelines, commercial expectation. What is your take on that?
Good afternoon, everyone. Thank you, Jitendra Bhaiya, for the question, and thanks to EIRC, ICAI, EIRC for giving me this opportunity to join as a panelist with this esteemed panel. So, straight coming to the question, what I have felt there, IBC is a paradigm shift for our economy, especially the corporates. When we come to the friction side, as and when we started implementing on this as RPs, as liquidators, on the process side, the legal side, we realized that each phase of IBC has got some friction or the other, which is going to the court or to the forum for adjudication. Now, what are those friction? The first friction, as RPs, we have realized that it starts from the formation of the committee of creditor itself. The creditors are primarily formed with the banks, financial institutions, the financial creditors who have lent the money to the company. The first friction is there. Who are the rightful financial creditor to have the voting right, to have the power to sit and drive the whole process? That's the first thing. The second stage of friction arises when we realize that when we come out with an EOI and when we have the list of final prospective investors, bidders who can apply for the bidding process or the resolution process, where we see that a lot of litigation enumerate out of that document itself. Why I have not been allowed, why I cannot join as a co-investor, why I cannot come as a, as an individual to invest. So the process document itself creates a lots of friction among the prospective bidders. The next stage is the resolution plan stage, when the interested bidders, after doing the due diligence, they feel it is important for going and the asset is viable enough to bid for it or put a resolution plan, where the resolution plan states the RFRP document which we make, again, should be a document which should be properly legally vetted in terms of law, also in terms of the procedure. If it lacks any element which may create friction again among the bidders, they find a scope to again litigate it. The last stage is again post-resolution. We see nowadays it's become very common that post-resolution, the stakeholders who come across the resolution plan through the court procedures or otherwise, they have now the rights to intervene in the process. And then they say that, this resolution plan doesn't offer me the exact value or my rights in the company. Hence, I have the right to intervene. And you may consider the other bidder, their plan may be a much better plan. So rerun the process. So in short, there are these 4 levels of frictions which as RPs we have come across. So as RP, I will just suggest that, every stage where we come across such friction, we be very carefully evaluating the process, the document, the law which is there, the provisions, and be very meticulously move ahead in the process so that we are not prone to these challenges. We try to make it more lucid and simplified for whosoever comes in the process as part of the resolution plan.
Yeah,
Thank
you, Nitin. I think I'm also on the same boat as you are. You see friction everywhere. All see, there are a lot of friction in every interaction, in every process, and it is up to the RP or IRP who takes it process smoothly by resolving the litigation, resolving the friction in a most balancing way. So I said, Tanya, I'll come back to you. Supreme Court in Swiss is basically, let us see now the real expectation and valuation perspective of IBC nowadays in current situation. Supreme Court in Swiss Ribbon said IBC is a beneficial legislation. Now we look at the operational creditor, they get nearly negligible or nil amount in any resolution process, take it. Even I can say that in maybe 50 resolution I have done, they haven't got even 1% of their dues. So whether liquidation value, is it a myth for an OC? Or maybe there is a requirement of amendment of section 53, which places the OC at 5th, 6th position. Or maybe the litigation can be resolved through, these amendment or the amendment in this respect. So what do you think that what is the main litigant area which could make the IBC more smoother in this respect?
So see, yeah, this is a very critical question because day in and day out we are seeing resolution plans where operational creditors are getting nil, somewhere it is nil and very negligible amount, whereas I believe in an economy, the FCs definitely they play a very vital role in bringing the financial credibility, but the economy is run by the MSM. They form the basic framework of the economy, the MSMEs and the OCs. So that comes to the question, yes, definitely I believe there should be an amendment. At least some critical OCs, they should create a class at least for them because they are the ones who is totally into supply chain OCs, who is important for the running of the business as well. The companies which are being sold as a ongoing concern. So basically IBC was taking over the company as an ongoing concern. That is the primary objective of IBC. So some prioritization is required, some amendments to carve out some priority to critical OCs, I believe.
Yeah, right, Tanya, I was expecting this answer from you, advocate with some commercial, a sensitive commercial sense, so who looks after the welfares of OC also. So, and now let me come back to Rohit sir. Sir, you have been in as a bench member in NCLT Kolkata. Now we see this commercial wisdom, this has been blown out of proportion even by the highest court. wherein Supreme Court in its judgment in SR Steel said that commercial wisdom of the COC is paramount and NCLT should not second guess it, right? However, as a judicial authority, you are the final check on the fairness of any resolution plan approval. So when a resolution plan comes to you, which is legally compliant, but offers, you see, a variable amount to the commercial or to the other creditors. So do you feel that your hands are handcuffed in such situation, citing by the judgment by the highest court that you are not required to look into the commercial angle? So what is your view in this?
Thank you, Mr. Lohia. Hello. Being heard?
Yeah, you are.
First of all, I may not agree with you. Handcuffed. We are never handcuffed. We are bound by law. We are in a democracy. And while the legislation is framed, objections are invited, suggestions are invited. I don't know how many of them are really taking the active participation in this process. At least I am not. I don't know how many of you. But these forums can, of course, take initiative because there is a process going on. This is the time. And the inputs which we generate from such conferences or such platforms must go there. Because you are all professionals, you are on ground, you know the realities. That's one. Second is that COC's wisdom this is true that it is supreme. But I tell you, it has to be legally compliant. There have been instances that the resolution plans have been set aside because there are certain basic requirements. It is provided in section 30 also. It was subsequently introduced that the COC has to record the deliberations of its meetings, meaning thereby they has to show that there has been application of mind while accepting or rejecting a plan. There have been many cases, Mr. Lohia is aware, in Calcutta also, the resolution plan was set aside only on this ground that there was no recording of the deliberations. And when it was sent back to the COC, it came and it approved another plan. So the reasoning, in law, reasoning is very important. It shows the, the decision, how the decision has been taken. We are not saying that the NCLT can substitute the commercial wisdom, but there has to be some reasoning recorded why the COC did this, and this has to be recorded. Now you see, in case of Jet Airways case, Honorable Chief Justice of India, Justice Chandrachud's judgment, if you read it, there have been some guidelines laid down for the resolution professionals and for the COC also, which further takes care of this, that the COC has to record certain reasons, the deliberations, how this decision was arrived at. So on this ground, the NCLT has set aside many a times these plans. So NCLT is well empowered to ensure that it is legally compliant. See, once the legislation is framed, it is a presumption that it takes care of all the aspects which may be involved into that. With the passage of time, we face certain problems, we see that there are certain deficiencies. That is, again, I said it's an evolving process. Now, this, as a part of the evolving process, this draft legislation is there. If there are some suggestions, like it was said that there should be something for the operational creditors, unless and until they see, it is not a very easy, it's a very complex exercise. Mr. Gadia can throw it, it's a very complex. Simply bringing the amendments is not enough. There has to be a entire thought process. So I would say that it's not all that the NCLT is helpless or we are bound by law, and whenever there is a requirement, the resolution plans have been set aside, and the COC's decisions have been, set aside.
Right, sir. I stand corrected in the perspective of while saying that the judicial are basically handcuffed in a way. It's a different perspective wherein you see there is a feasibility and viability which can definitely be looked into by the bench. So while presenting a resolution plan, and it's a very important aspect wherein we as an RP often try to miss on that aspect. It is not only about the commercial figures, it's not only about the amount being offered to the creditors, but the feasible and viable. I mean, if the plan offers something, some amount, but the feasibility and viability of the plan itself is missing. So that is where judiciary can step in and even reject the resolution plan. Sir, coming back to you again, on one more important aspect is the value preservation because of the delay in admission of the CIRP cases or maybe insolvency cases at the admission stage. The law was originally envisaged wherein 14 days was the time limit given for admission of any case if Section 7 is filed. There is no requirement of seeing a default, but nowadays you see, you have even seen there is a draft amendment which is going to come in, wherein even if there is a default recorded in NSCL, so there is nothing required to be seen, and even mere filing on application will lead to admission. So how do you think that this would stop the value erosion, or is this a correct proposition which is, you see, coming forward through an amendment, wherein the corporate debtor will not have any say and there would be an automatic admission of the CIRP without right of natural justice? So what is your take on this?
See, Mr. Lawyer, we all know that IBC was supposed to be a 100-meter sprint or a T20 match, but we see it as turning road to be a 5-day test match. The delays are there, of course, but saying that 14 days, it's very easy to, there was a famous movie maker, Walt Disney. He said that it's very, everybody wants timelines. So my experience as a lawyer, or on the other side, I don't think that 14 days only by saying it can really work. Now we see that there's a draft amendment that information utility, that information will be enough for the adjudicating authority to admit this petition. Personally, I have doubts. Personally, I have doubts about its reasonableness. As Mr. Loya said, the principles of natural justice. There can be many cases where can be, the corporate debtor has done a set of his debts. But and I tell you, I have not seen many cases. Now maybe there in the last year or so, I have not seen many cases. Maybe not more than one or two, where the financial creditors came out with this information utility information. I've been asking many bankers also why it is not happening. They may be having their own reasons. First of all, this is not happening. So let us not, unless and until this is actually, we have to match the speed of, unless you are making a law that information utility is the ultimate thing. But how many banks, my friend is there, she can tell that in how many cases in the NCLT, Mr. Loya is there, everybody is there, in how many cases the financial creditors, the biggest financial creditor perhaps is State Bank of India or the Punjab National. In how many banks they are coming up with this information? Why they are not coming? I am not on that. First, let us make them, it's workable, then let us make it. Otherwise, simply amending and saying 14 days, I have my doubts that if it can effectively work.
Right, thank you. I also have my own doubts on this, that 14 days should be the mandatory provision wherein, but let us see that how the law evolves. Coming back to Mr. Garia, sir, you already have said that there is a good recovery from the side of, from the perspective of resolution applicant, SRA basically, in you see, turning around the company and even they are getting a loan at a very lower rate of 9%. So from the perspective of banking industry, from the perspective of stress industry, so is it the IBC, on the guise of commercial wisdom, they just want to clean up their books and write off their balance sheet so that their capitals are not eroded, they are able to reduce their NPA percentage, or genuinely they are trying to revive the company or maximize their value through an IBC process?
Sir, there are two more questions which were going on. Just wanted to share my opinion, whether IBC is an evolving act, and people are saying that it is evolving. If you consider as the case laws also as an important jurisdiction कि सर एक्ट हो गया और एक केस लॉ हो गया important, उसके बेसिस में हम लोग एज ए लॉयर आप लोग डिसाइड करते हैं. तो यदि कॉन्स्टिट्यूशनल एक्ट, तो इंडिया का जब कॉन्स्टिट्यूशन बना था तब कॉन्स्टिट्यूशन बना, एंड लेबर एक्ट विच आर वेरी वेरी ओल्डर एक्ट. सर आईबीसी के अंदर में जितने इंपॉर्टेंट केस लॉज आए हैं लास्ट 2 साल में, यदि 100 आए हैं, और जो भी एक्ट के अंदर अमेंडमेंट हुआ, अमेंडमेंट और इंपॉर्टेंट केस लॉज, इफ देर आर 100 इन आईबीसी, देर आर अप्रॉक्सीमेटली अराउंड 1000 in labor act and approximately around 700 in constitution. So I'm just trying to say the any act which are so older, which are around 40-50 years old act also, they are also the important case laws and also the important amendment which are approximately around 10 times more than the IBC. So whether IBC is an evolving act or not, it is up to us to decide. The second question, whatever everybody is asking about is SARFAESI versus IBC, this is there. So we are absolutely now, banker used to confuse themselves कि जब IBC नया आया था तो everybody used to push because whenever there is any stress asset or whenever there is any NPA happening, बैंकर्स के पास में 5 चॉइस है कि सर वो प्रमोटर के साथ में OTS कर सकता है, वो प्राइवेट ट्रीटी कर सकता है, वो सरफेसी कर सकता है, वो DRT कर सकता है, वो NCLT ले जा सकता है. 5 ऑप्शन है उसके पास में. कौन सा ऑप्शन कब एक्सरसाइज करेगा उसकी बात है. तो मार्केट हैज नाउ मैच्योर्ड एनफ. I can only tell that for the IBC, if the 3 conditions are qualified, then the asset will go for an IBC. If one condition is, what are the important criteria through which we can decide which asset will go in what sort of recovery mechanism? If it is a big asset, if there is a multiple stakeholders which are involved, in case if there is a big asset, in case if there are multiple stakeholders involved, then it is the IBC process which will get into it. यदि हमको रिकवरी खाली एसेट बेच के ही लानी है तो सर हम आईबीसी में नहीं जाएंगे, हम सर सरफेसी में चले जाएंगे. हम उसमें टाइम वेस्ट है, इतना लिटिगेशन हम क्यों करें. यदि हमको एसेट बेच के ही पैसा रिकवर करना है. तो इन केस इफ़ यू सी दैट ऑल द रियल स्टेट केसेस, अभी जैसे नया सीमेंट प्लांट आया, कोई भी चीज़ आया, तो देर इज़ ए पैराडाइम शिफ्ट. देर इज़ बिकॉज नाउ द बैंकर आर नाउ क्लियर कि किस एसेट को किस में लेके जाना है. वो ऐसा नहीं है कि वो आईबीसी में नहीं लेके जा रहे हैं कोई चीज़ के लिए, लेकिन अब सबके लिए रास्ता, हर एसेट क्लास के लिए, जैसे हर एसेट क्लास के लिए, हर चीज़ के लिए हर तरीके का रास्ता बन जाता, तो सबके लिए अलग अलग रास्ता बन चुका है सर कोई चीज़ के लिए. तो दिस आर द 2 पॉइंट्स. थर्डली, इफ़ यू टोल्ड कि सर बैंकर्स के लिए क्या, बैंकर्स किस तरीके से अपनी बुक्स क्लीन अप करता है, वो आईबीसी खाली एक क्लीन अप का मैकेनिज्म है, यानी क्लीन अप का मैकेनिज्म है तो सर वो एआरसी सेल कर देगा. सर क्लीन अप का मैकेनिज्म यदि करना है तो सर ही विल गेट इनटू सम सॉर्ट ऑफ एन एआरसी मैकेनिज्म वेयर ऑल द 99% ऑफ द एनबीएफसीज व्हाट दे आर डूइंग, इन केस इफ दे वांट टू रिड्यूस दिस ग्रॉस एनपीए, दे विल जस्ट सेल द एसेट पोर्टफोलियो टू द एआरसी वेयर रिकवरी इज ऑल्सो डन बाय देम. So in cleanup mechanism, it is the ARC mechanism. As far as IBC is concerned, again लोगों ने बोला कि बैंक नहीं लेके जा रहा. मैं खाली आपको कुछ स्टैटिस्टिक्स और नंबर्स जिससे आप डिसीजन अपने आप निकाल लें. सर 3 साल पहले स्टेट बैंक के पास में 3,58,000 करोड़ के स्ट्रेस एसेट की बुक थी. देयर वर 2 चीफ जनरल मैनेजर्स, देयर वर 6 जनरल मैनेजर्स विच आर लुकिंग आफ्टर द एसेट क्लास. नाउ एज पर एज द स्ट्रेस एसेट के डिवीजन के अंदर उनके पास सिर्फ 58,000 करोड़ के एसेट रह गए हैं. तो नाउ देयर इज ओनली 1 चीफ जनरल मैनेजर. जब इकोनॉमी अच्छी चलती है तो स्ट्रेस एसेट नहीं बनते हैं सर, और प्रमोटर को खुद ही आके उसको रिवाइव कर लेता है. प्रमोटर खुद ही आके उसके लिए रिस्ट्रक्चरिंग प्लान ऑफर कर देता है. बिकॉज 3 साल पहले तक उस प्रमोटर जो सिक था या कोई प्रॉब्लम थी, प्रमोटर के पास उसका रास्ता नहीं हुआ करता था. अब तो उसकी रियल स्टेट की एसेट बढ़ गई है, उसको एक इन्वेस्टर मिल जाएगा, उसकी कंपनी के लिए कुछ काम मिल गया. तो व्हेन द इकोनॉमी इज डूइंग गुड, तो प्रमोटर इटसेल्फ स्टार्ट्स कमिंग अप विथ हिज ओन रेजोल्यूशन प्लान, और खुद ही जाके बैंकर से सेटल का कर लेता है. तो आज के दिन के अंदर में कि ये माने बैंक के पास में परसेंटेज ऑफ स्ट्रेस एसेट टू आईबीसी यदि आप देखेंगे तो बैंक के पास में लोन टू स्ट्रेस एसेट का परसेंटेज हैज रिड्यूस्ड. दैट इज व्हाई द IBC process, and IBC process has absolutely matured a lot into my opinion. There are some important case laws and other things which we might delay for our own interest. There are lawyers and other things which might delay it for our own interest, but we know heart to heart कि मेरे पास अभी पैसे का जुगाड़ नहीं हो रहा है, कुछ और नहीं हो रहा है, तो मेरे को इसको डिले कराना है, कुछ और काम करना है. We can do it all sort of tricks. जितेंद्र भाई, thank you.
Yeah, thank you. So, ज्योति सर ने एक चीज जरूर ठीक से बोला कि भाई banks are confused. So it is about the asset, it is about the company. How do we want to resolve it? Every case might not be resolved through insolvency process. So that perspective has to be seen, not just कि भाई IBC में haircuts हो रहे हैं. There are no haircuts if you see from a different perspective, right? So, but yes, where there is a complex cases, where there more creditors are involved, a company is going concern is still not able to resolve. There are a lot of statutory dues. So then there could be a good resolution under IBC. So Nitin, you have been an insolvency professional. So coupled with this, that yes, there could be a good resolution under IBC where a lot of factors are involved. But the resolution timeline, 330 days was the original. But nowadays we see that the timelines are getting extended basically. Even the extension is being granted multiple of times. When we go to courts and court grants the extension, although not envisaged under the law. Even by way of exclusion, we are getting the extension basically. So we usually blame NCLT for these backlogs and all. But as an RP, as an IRP or as an liquidator, are we also not to blame? We do not foresee that these processes are to be completed in a time-bound manner which we have been given to, and resolve this litigation, resolve these inordinate delays which is causing, you see, by applying a more judicious and proactive mind. So how do you deal with this situation as an insolvency professional?
Sir, first of all, let us correlate where we stand in terms of the timelines, the timing delays. I'll just give you an example. If 2010, when I was going through one of the cases, it's an international arbitration in Singapore, where I understood that the creditor was going through a judicial management process. I was first of all confused, what is the judicial management process? There were judicial managers in the company who was running the company instead of the promoters. And that was a shipping company. And Deloitte was appointed as the judicial manager of the company. We saw that over here where in India things have matured to the resolution process stage, there were judicial management who were running the company over there instead of the resolution initially. Over there also the first instance was to how to recover the dues from the debtors, from the assets instead of resolving here. So we quickly go for a resolution here, but end up in litigations because of the loopholes somewhere in the system which have been tried to be filled up through a lot of amendments by the judiciary, our regulators, the government, where the IBBI has amended law from 180, 270 and then 330. But then that 330 was not made mandatory. Through some of the cases, there were some exclusive cases which were granted that exclusion of timeline even beyond 330 of litigation, but unfortunately, that has been left open-ended now. Now it is common to every case. Now it has become as a precedent in every case. So now as an RP, when we talk about RP, what is most important for us is to stick to the basics of the IBC, what is laid down in the code. We should not get carried away what are the cases which have been precedent judicial pronouncements which have been made, who is going to do what, who is going to litigate. But if we are strictly drafting and crafting our procedure, it's as an RP, we are following the process in the law. We are given a set of documentation which has to be prepared from our own. Those documents are not standard documents which are laid down in the law itself for the time being. So maybe once the law is amended to an extent where the process documents have to be made in a specific form, giving these details, etc., etc. Unless that happens, the timelines cannot be kept to the law because we face these challenges time and again from various stakeholders who are taking the case to the court. However, we have seen that all the judiciaries had at least acknowledged the fact that the process has to end somewhere. At least they are taking that call that resolution should happen, irrespective of whatever the litigations are there. They are taking the call on the resolution plan to be approved as a primary thing in the whole process. So at least the resolution plan is taken to a level to be approved. Thereafter, so many other litigations which keep happening, at least as an RP, we succeed to get the asset resolved. We should not be carried away with whatever litigations are happening, but focus on the resolution plan process to revive the company out of the troubles.
Yeah, thank you, Nitin. And follow-up question to you, just before we conclude this panel discussion, maybe this last round. Our topic is reinventing stakeholder value. So as a resolution professional, what is one thing you want to change under the insolvency and bankruptcy code as a resolution professional? As you said that you, as a RP, as an insolvency professional, we are trying to resolve in a time-bound and value maximization manner. So what is that one thing which you want to change?
If we have to talk about one thing, then I'll suggest that the regulators and the IBBI to at least look into the process of bidding that be made as part of the code, so that the issue of transparency at the time of the resolution plan voting, or maybe revival strategies which has been discussed among the COC members, the bidding process, the bidding evaluation matrix, etc., whatever they are as part of the law itself, should be made as part of the law to be a transparent process, so that we don't, the COC or the RP don't evaluate their or formulate their own procedure for bidding. So let it be a part of the law itself, where maybe a separate set of regulations or rules on the bidding process or the mechanism to be followed in terms of evaluating a particular resolution plan.
So you mean to say basically that everything should be in the law itself, so there is no ambiguity in this regard. So maybe in that case, the banker would one day say that why an RP is required, we'll let us follow the process and no RP is required. So just on a lighter note.
But the RP is required to follow the law. Who will channelize, who will run the show? The COC cannot run the show.
Yeah, just on the lighter side. Let me also have a concluding view, because we have to take some questions from the audience. They are waiting so long to have a question to our esteemed panelist. So Tanya, as an advocate, right, don't take me wrong, just on a lighter note, more litigation, the merrier, you see, our profession is. More the fees and more litigation, it goes on for decades. But as a professional, can we, or as a professional, not only you, I mean, as an advocate or we as an RP, can we not resolve to, you see, conclude a case in a proper resolution way in a shorter period of time? So there are hospitals, you see, which want to keep the patient for an indefinite period of time. There are hospitals in South, we understand that they want the patient to be discharged immediately so that new patient can come in. So can we not build a culture so that we somehow try a better resolution maybe within 270 days? Yes, this is resolved, everything, no litigation. So there is a resolution plan fully implemented, that's it.
So this perception definitely exists, but you know, as professionals, especially when I talk about myself, I always encourage clients for settlement, going for mediation. One prime example in very recent year, it happened just this year only. So in one of my, it's a very recent thing that has happened. So in one of the account, there was the CIRP going, and there were 13 consortium members, and there was one member, financial creditor only, so they couldn't submit the claim within 90 days. So the RP definitely, she admitted the claim, and when it was put on vote before the COC rejected the same. So as per regulation 12 and 13, the RP also filed an application, and simultaneously the FC also filed an application. I went for a meeting, the RP also invited me in the COC meeting, and I convinced the COC this will unnecessarily prolong the litigation. Even if NCLT favors in our, rules out the judgment in our favor, definitely the FC will go to NCLAT. So, these definitely mitigating litigation, and as a professional, I always push for settlement, mediation. So that is what, as professionals, we should also push. In fact, portraying the COC, the pros and cons of any litigation will definitely help this thing.
And one last, in just 2 lines, what you want in the entire process to be changed, if you have a power to change something in this IBC law?
First of all, though, I don't have that much of power, but definitely I believe, see, as we are seeing, it is, day in and day out, we are seeing amendments. Every year almost we are seeing amendments, and there are certain very good amendments. For example, the NESL one, definitely I wouldn't say that it is a very good amendment, especially when we see that NESL is boarded with work. For a NESL report for the bankers, it almost takes them 5 to 6 months to avail that report. So, and these little bit amendments are very important. Extensions should be restricted, what I believe, because time is the essence, as we all know, time is the essence. When we see a company, everything gets eroded, especially when we see the plants, steel plants or a power plant, we see that the erosion is too much there.
Right,
So,
I
yes.
got you. Let me come back to Jyoti sir. So, sir, with your concluding remark, I would also like you to hint on how the stress asset investors are navigating the CRP process, or post, when you already said that, yes, there is an investor, there are investors, they are getting the company, but are they making a money? After the, you see 2, 3 years, 4 years of running the company, are their top line is increasing? Are their net profitability is increasing in the absolute way? So, and what exactly, you see, how do we see this IBC going forward? Your last concluding remarks on that.
First question was that what amendment which I think need to be required. I think so there are 2 basic flaw in the IBC Act which need to be curbed at. कोई चीज़ पास करानी है तो हमको 66% वोट चाहिए, यदि हमको नॉनसेंस क्रिएट करना तो हमको खाली 35% वोट चाहिए. तो मेरे को लगता है कि ये एक बहुत बड़ा एनोमली है. और सेकेंडली एक एनोमली है कि COC के आपस में दी इनफाइटिंग हो गई. Then there is nothing else where the IBC can come and say. IBC ने बहुत सारे बोला है कि creditor ये होगा, वो होगा. If there is a infighting or there is no consciousness arising between the COC members itself, then the IBC Act is a silent, and how these वो majority 35% वाला stake. So these are the 2 things I think so definitely these are the 2 loopholes which are there. I think so we need to act upon that. Second question which is being asked, in case if the company which are being taken over and now after the IBC के अंदर किसी ने company ली है, तो how those companies and assets has been performing. I think so approximately all the listed entities that we have worked with, whether it is largest jewelry company or it is an infra company or it is a defense equipment company, listed entity का यदि हम barometer लें, or any company, any of the company listed entity which they have acquired any stress assets also. यदि उन्होंने यदि 100 crore का asset acquire किया है, तो the market cap of that company has increased by 1000 crore. Like 1:10, I'm just trying to say कि यदि आपने 100, because market thinks कि आपने बहुत कम में acquire किया होगा. Market तो definitely in terms of the share market perception also, if you have acquired any asset, so market gives you the reward of at least 10 times the value that your market cap gets increased there. And also whatever the listed entity, but यदि वो 100 crore की आज या 20 crore की market cap की company, any of the listed entity, if they have been able to revive themselves, those are approximately around 1000 times or 2000 times. That is why you will always see that there is a lot of tendency in the people कि listed stress asset के अंदर हम लोग पैसा लगाते हैं, हम लोग चाहे punt ही लेते हैं, लेकिन we think कि यदि 10 में से यदि 2 company भी चल जाएगी तो उसके अंदर हमको ठीक हो जाएगा. So this is the perception. And lastly, in terms of, in case if it is a non-listed entity also, again, I am saying that I am yet to come across any company where the promoter or the owner or the investor or anybody who has invested in stress asset, he has lost money. Thank you. He has lost money. Sir, nobody has ever lost money
Right. So,
while dabbling in stress assets, sir.
so basically, Jyoti sir is saying that market is right now, I mean, it's
Absolutely buoyant, sir.
riding very high. So it is a parameter of the stress company being taken over by the listed company.
Absolutely.
So, yes, and sir, I mean, I'll not pose any question to you. So I'd like you to give a concluding remarks on way forward how the IBC should, or maybe you see, for the resolution professional industry, RP industries or insolvency professional industry, how we are thinking in this aspect.
So what is the topic? Today's topic is the
Rethinking stakeholder value.
stakeholders' value under IBC. So I would only add 3 words. The biggest destroyer of stakeholder values under IBC are the delays. And for the delays, everything, you can't fault the code. As has been told by Mr. Gadia also, and my friend on the bankers also, Mr. Loya also was saying, we also have to play a role as a professionals. We must appreciate how to minimize, cut down the times. Mr. Parasuram Puria is a little smiling, but I can see that a time has come that we must, because otherwise if it becomes a normal adversarial litigation like in the civil courts, then it may not be possible to achieve we also require some our responsibility. We are working for a 5 trillion economy, and we want our country to be vibrant and seen on the this world map, the best. So we must contribute, and we are the chartered accountants, they're the company secretaries. It's a very unique platform. Perhaps this is the only one. So we have an important role to play in the larger interest of the country also. And let us do our best. Let us appreciate that this has been brought into for the larger interest of the public, the citizens of this country. We must think in those terms also. Thank you so much.
Thank you. Yes, we all agree, sir, when you say that it's a very vibrant law for a vibrant economy. Before we conclude, can we have maybe 2 or 3 questions from the audience? Yes, Abhishek ji, can we have some mic over there?
Yeah, good afternoon, everyone. So one of the things I believe, we are talking about stakeholder value, and one of the important things I believe is like the PUFE applications. There is preferential, undervalued, extortionate, and fraudulent transactions. And as a resolution professional, in my experience, most of these applications do not see any tangible outcome. And that actually destroys a lot of stakeholder value. So my question is, like, what amendments are required, or what the resolution professional should do so that these transactions, these applications are see the light of the day, and so much of stakeholder value can be then preserved. Thank you.
You say the light of the day. You said the light of the day. Can you explain what do you mean?
So what is happening is most of these PUFE applications, right, they are not actually getting the desired outcome, what I would like to say.
What do you mean by outcome? Is not being decided, or decided not getting the outcome? There are 2 things.
Right. So what is happening is, the point of view which the RP has at the time of filing, that is not, for whatever reasons, law or otherwise, it's not getting expressed in terms of a favorable outcome.
See, you have raised a very, very important question.
Right.
Very important, because we see in a lot of, the conferences and everything, this aspect, Mr. Gadia can, he's an expert into finance, I'm not, but I can say that it's a very, very important aspect in following the timelines in 7, 9 petitions and the resolution plans, 43 applications, they're being decided, but not in the speed they should be. They should be. I'm in agreement with you. Sure, buffet transactions also need some kind of priority like other applications 7, 9 and the resolution plans. Mr. Gadia can, because he has his experience in.
Sure. Whenever any case is referred to any stress or NCLT, उसके पहले एक forensic audit हो जाता है. Unfortunately, after this buffet transaction, in terms of the forensic audit, whatever, in forensic audit, the buffet transaction का जो scope of work है, it is कि whether the pricing it at arm's length or not. जब आप forensic audit करते हैं, तब आप ये बोलते हो कि pricing या मैंने जो सामान खरीदा है वो arm's length में लिया कि नहीं लिया. और फॉरेंसिक ऑडिटर ये बोलता है कि आपने ड्यू प्रोसेस फॉलो किया कि नहीं किया. ड्यू प्रोसेस था कि आपने बोर्ड को बताया जो भी आपको करना था और आर्म्स लेंथ में ट्रांजैक्शन हुआ कि नहीं हुआ. तो बुफे ट्रांजैक्शन जब आपकी एनसीएलटी आने से पहले जब बैंक जब फॉरेंसिक ऑडिट करा रहा है तो फॉरेंसिक ऑडिटर ये 2 पॉइंट देख रहा है. जब आरपी जब आके बोल रहा है कि सर ये तो आपने अपने भाई से सामान खरीदा है, यदि आप ये प्रूफ कर सकें उसकी अपने भाई से सामान खरीदने के साथ साथ कि सर कि पहले जो फॉरेंसिक ऑडिट हुई है इसके अंदर ये 2 पॉइंट कि सर ये मार्केट रेट पे नहीं हुआ या ट्रांसफर प्राइसिंग मैकेनिज्म में या प्राइस गलत थी या फिर ड्यू प्रोसेस फॉलो नहीं हुआ. हम ये तो बोल देते हैं कि सर इसने अपने दोस्त से सामान खरीदा, भाई से सामान खरीदा, लेकिन उसके पहले तो फॉरेंसिक ऑडिट हुई है ना उसके अंदर ये 2 ट्रांजैक्शन एस्पेक्ट चेक हो चुके हैं. इसके लिए बुफे ट्रांजैक्शन ज्यादा स्टैंड बाय लॉ हो नहीं पाता है. तो एज एन आरपी इफ यू वांट टू डू यू हिट ऑन दिस 2 पॉइंट. आप बुफे को हिट मत करिए. आप ये मत बोलने जाइए कि मैंने इनसे माल का खरीदा, मैं तो रोज इसके साथ, ये तो अपने भाई से माल खरीदा, ये मत बोलिए. आप ये बताइए कि मैंने प्राइस का जो रिकवरी मैकेनिज्म था वो ठीक से फॉलो किया कि नहीं किया और मेरा जो प्रोसेस था रिलेटेड पार्टी ट्रांजैक्शन का वो फॉलो किया कि नहीं किया.
Sure, thank you.
Right, any more questions from the audience?
Myself, Sumit Jain. I'm an IP as well as an arbitrator. My question is to Rohit Kapoor, sir.
Can you increase the volume?
Yeah, sir.
Hold your mic closer to your mouth.
My question is to Rohit Kapoor, sir. So, sir, how do you see the ADR mechanism in the IBC ecosystem in present and in future? And its impact?
Alternative dispute resolution.
ADR? ऐसा है कि ADR अगर उसमें आप रेफर कर रहे हो, because arbitration is one of the, okay, I see a interplay between IBC and I see a lot of interplay between this arbitration and the IBC. And we had the occasion to take a call on those because the arbitration matter was going on. I should not be quoting the name by the former Chief Justice of India, and and there was a moratorium. It came to us whether the arbitration, and that in the case of operational creditors, suppose an operational creditor is there, and suppose corporate debtor, he has an operational creditor, okay? The corporate debtor, uske against insolvency proceedings initiate ho gayi, let us say for 2 crores of rupees, because threshold is 1. लेकिन corporate debtor ने एक आदमी से 20 करोड़ का award लेना है, and award has been, it has attained finality, it is pending execution before the the executing court. Civil courts, you are a lawyer. But because of the litigation delays, it is not being taken up. उसकी insolvency हो जाती है, उसके award का क्या होगा?
Sir,
So it is an area between the arbitration. It's a very serious area. While we're talking about the, it was being mentioned that the operational creditors को या उनके जो उनको क्या मिलता है?
Yes, sir,
It's a it's an area.
sorry to interrupt. My question was from some different perspective. As Mr. Lohiya ji was saying that we are probably expecting some direct admission of cases and also,
Acha, ADRs, you want to say some kind of a mediation?
no, yes, sir. So basically, is there any, at the policy level, something going on wherein we can see the direct admission of cases, but prior to that, some ADR.
Pre-mediation, like in commercial courts, you say. Like in commercial courts. We don't have formally enforce any such mechanism under IBC. But definitely, once a demand notice is issued, I think the buyer knows. See, the only thing which I see from my perspective, I may have, passed around more than 100 orders in the 7-9. What change I see on one line? There is a behavioral change in the mind of a corporate debtor, of a borrower. They want to pay. They know that now the things will not get delayed. If they are seriously, the promoters, if they are serious in the business, if there is a default, they try to pay. This change I see under the IBC.
Yes, it has happened.
So, thank you. We have to close this session. All good things ultimately comes to an end. And thank you to all the esteemed panelists for your wonderful deliberation and enlightening us through your varied knowledge. Let me also conclude by this, that value is not a number. It's a negotiation, perception, and shared responsibility by all the stakeholders. Today we have seen how IBC ecosystem can evolve toward fairness, efficiency, and true stakeholder protection. So let us all give faith and be patient and give some time to the IBC to further evolve. This is a very good piece of legislation. So with this, thank you all for joining us in this panel discussion. Now I hand it over to for the formal vote of thanks.
Yeah. Satish ji, please.
Dear friends and colleagues, as we come to the concluding moments of this wonderful session, it's my honor to present a vote of thanks. Firstly, I'll express my gratitude to Sir Rohit Kapoor for sharing his experience in NCLT for preserving the value of the stakeholders. My heartfelt thanks to other speaker of the panel, Mr. Jyoti Gadia, Mr. Jiten Lohiya, CS Nitin Daga, and Advocate Tanya Barnwal. Your participation has elevated the session and helped us rethink the shareholders' value in a holistic way. I also thank all the participants who have enriched the session with their insightful queries. And last not the least, I thank EIRC for organizing this kind of meaningful session, which will be immensely helpful in our professional assignment. Thanks once again, and have a wonderful afternoon.